It's going well. It's warm.
Okay, Greg.
All right, so my name is David Weinstein. I'm a copyright attorney. I also do I'm non-patent intellectual property, so I do trademark and copyright work. And I've been practicing law for 49 years. I was born and raised in Denver, and after I graduated law school here, I moved back to Washington, D.C. and worked for the Patent and Trademark Office. At that time, it was called the Patent Office, so a number of years later, they added trademarks to it. And my work there was as a trademark attorney, examining applications that people filed to federally register their trademarks with the Patent and Trademark Office.
Was that at the Crystal City one?
Well, it's interesting. When I first started work, I worked at the Commerce Department because the Patent Office was located in the Commerce Department on Constitution Avenue. And they had built a new facility in a group of buildings near a national airport called Crystal City. And so the trademark office wasn't there initially. It was initially where I worked above a drugstore in Connecticut and Rhode Island. The drugstore was Welland's Drugstore, and it was DuPont and Connecticut, if you know anything about, below DuPont Circle, if you know anything about Washington, D.C. And the trademark office moved over subsequently to the Crystal City complex and was there alongside the Patent and Trademark Office. The trademark group is much smaller. At that time, there may have been 2,000 or more patent office employees. The trademark office had about 300. And when I was there, there were only 40 trademark examiners. I think perhaps patent examiners are maybe 400 or 500, so there were significantly more. And I'll explain a little bit about the difference between patents, trademarks, and copyrights, because you probably hear those three words used together, sometimes separately. And they all reflect a type of legal right that you can acquire with respect to things that people create. Usually the creation begins in your mind, and then it manifests itself in inventions, devices, or processes. So a patent, Roger's probably explained to you patents, or you've had other people talk to you about patent protection. It's a legal right that gives inventors a monopoly for a limited period of time to prevent other people from making, using, or selling what's covered by the invention. And there are different categories of inventions. So you can't have a patent until the patent office examines your application. And I'll tell you a little bit about how copyright fits in there. And once the patent office examines your application, your patent application, and if the examiner feels that it merits protection, then a patent will issue. And the patent period now has changed. It used to be 17 years from the time that you got the invention, that the patent, and now it's changed to a longer, it could be a shorter period because it's 20 years from the time that the patent is filed. In the past, people would file a patent and then hopefully delay a long time until that patent issued, so they got 17 years tacked on to that initial filing period. So I don't do patent work, and Roger's the expert, and he could tell you a lot, I'm sure, that he has and will if you have questions. But with respect to patents, it's part of that part of the agency, the Patent and Trademark Office, are together. Trademarks are brand names. So to have a patent, which is referred to as a legal monopoly, you can't have rights until the government gives them to you. That's different with respect to trademarks, which are brand names. You're familiar with Broncos and Cheerios and RTD and things like that, names of entertainment companies, names of products and services. And unlike patents, you don't have to have a registration. The government doesn't have to tell you that you have something to be able to have the rights. And it kind of ties in with copyright, because to have rights in a trademark, you merely use it in connection with a product or service. From a copyright standpoint, you have rights by creating something that falls within the categories of copyright. So if you want to supplement or get additional benefits associated with the rights that are attributable to a trademark, you can register it. You can register it with the Secretary of State. Each Secretary of State of all the states has an office where you can register a trademark, and you do that by completing an application form that's very non-complicated and paying a government fee. And trademarks from a state standpoint are valuable. I think that federal trademark registrations are much more significant and worthwhile if you're going to spend money, because you get national coverage. So to get a trademark from the Patent and Trademark Office, you file an application. Well, the process is a little bit different than the process that's involved with respect to state trademarks. The state trademark process is you file the application, you pay the fee, the government looks at it, issues a registration. With the federal trademark registration process, you file an application, you disclose what the mark is, you tell the office what your products or services are, when you first used it, and then there's an examination process, somewhat like the patents, not as rigid. And if the office finds that the mark qualifies for registration, it'll issue a registration. And why wouldn't it issue a registration? Well, it wouldn't issue a registration if the mark is outside the context of certain categories that are protectable. So generic words are not protectable. So you could not get a trademark table for table. If you did, you would preclude other people from having a right to use table to identify a product. So you file your application, the examiner looks at to see if there are any other registrations or applications that are filed on file. And if so, kind of like a patent in a way, they do a search for a novelty in a patent, but for trademarks, they look to see if there's anybody else who has a mark like that. If there is no one else, you can get a registration. So I'm simplifying the discussion. And I can answer questions at any time if that would be good. I don't have a specific.
I was gonna bring up one,
Sure.
it's just been
Sure.
in the news with
Yeah.
the Earharts,
Uh-huh.
the NASCAR racer,
Yeah.
there's a family dispute going on over
Who owns the
the
rights?
use of their last name
Right.
associated with certain
Uh-huh.
businesses. So the family is split up into two camps.
Yeah.
And it's like, they're saying, well, it's our family name, we have a right to use it. And I'm like, well, no, because there's other people with that family name and you don't get a monopoly.
Right. Yeah.
Right.
That's
On
true.
that.
That's true. You have the rights that you have for a trademark or applicable trademark are for product categories. So if you have a family name, that's one of the categories that there's a little bit iffiness with respect to whether you can acquire a federal registration. Why? Because a lot of people have the same name, and if registration was issued to one family for its name, that would in effect preclude other families from using and registering that mark. But the trademark office registers marks for categories of products. There's about 44 categories. They have medical devices, smoking devices, different food categories, different clothing categories, publication categories. So with the Earharts, I saw your question, I asked if it was all right, and we'll get to it. So with the Earharts, trademark rights are based upon, in a way, like patents. Patents is first to invent, correct? On trademarks, it's first to use. So the first person who uses, with respect to other users of the same mark for the same products or services, has superior rights. Okay, this is probably a good time to stop, and no, it isn't a good time to stop.
Okay. Question like the patent or trademarking of words like polo or entrepreneur that has been allowed. It's kind of limiting to people that are entrepreneurs not to be able to use that word. Entrepreneur Magazine has trademark that.
Well, actually, they can use that word. The rights that you have for a trademark, we'll use polo as an example. Polo is for clothing, so Ralph Lauren initially used that to identify products that have the polo player. So they can also be images and the word polo. So the rights that Ralph Lauren has with respect to polo is limited to clothing and any other product line that it uses it in connection with. So if I had polo for automobile batteries, that wouldn't violate, arguably, it wouldn't violate the rights, because the rights that Lauren has are for clothing. And people, the thinking is, people wouldn't likely think that someone who uses polo on automobile batteries also makes clothing. Well, in the age of conglomerates, you can make an argument that one conglomerate makes everything, but that's the general thinking. So,
And regarding that, it's like the numbers 5280. I had a domain name and a website called 5280weddings.com. I got sent a
cease and desist letter.
from a lawyer saying that 5280 magazine is not allowing me to use that 5280 weddings.
Right.
And it's a little frustrating. It's like,
They were thinking they were famous.
Well, actually, years ago, I was involved in a lawsuit as an expert witness in a 5280 case, and their argument is they endorse products. It's not what's called a certification mark or a good housekeeping seal of approval. When people see 5280 in Denver, they automatically, that's what 5280 says, they automatically associate it with that magazine because it signs are in restaurants, and they also are in a licensing program, I believe, where they license different companies to use that trademark for different products. So that's how they've expanded the breadth or scope of the rights that they have. Initially, it was for magazine publications. But what they did is they probably became well-known. People wanted to associate themselves with it, and they said, well, if you want to be associated with us, we'll let you use the mark under a license. And so they started probably adding categories. So it was initially food, and then maybe clothing, and maybe other types of products, other services. And so the question is, would 5280 for wedding services violate the rights of 5280 for magazine? And their position would probably be, well, you know, yes, we're associated with a magazine, but when we promote weddings, there's weddings in our magazine, and we have features, we have stories about weddings, we have wedding apparel, wedding services. So they basically expanded the scope of the rights they have by using it in connection with different products, allowing other people to use it in connection with other products, and by challenging people like you.
Well, did you have a federal trademark on that?
No, I acquired a domain name, I built a website, I posted it up,
Yeah.
Like, there's also 5280 chiropractic, 5280,
Yeah.
house cleaning services, I mean.
They may be affiliated. You don't. That's what you check to see, are they affiliated? And you know, I started out with copyrights, and I'm into trademarks, and now I'm into domain names because domain names can be trademarks. And so, generally speaking, to be able to protect a domain name, you have to use it. I mean, to challenge someone, you have to use it as a trademark because you don't have basis. And there are different ways to do that. So, anyway, that's trademarks.
But that is, it brings up a good point, like you could have had a federal registration, and this happens to get a federal registration approved, and then you get a cease and desist, because the trademark office is just looking at your associated goods and services, but the company with that name and another set of goods and services may feel that they're well known, and they can go off all the goods and services.
So again, we can go deep into certain parts and come back out and talk about other things that when we're talking about what Roger's suggesting, if you have a federal registration, that gives you some benefits, but not necessarily, it's not a solid thing. Simply because the Patent and Trademark Office has registered a trademark doesn't mean that no one else can use it. Basically, it gives you a registration, and you have to become the police person to go out and enforce your rights. And so the Trademark Office, the Patent and Trademark Office, looks only at its database, whatever marks are in its database. So if there's a 5280 magazine that never registered its trademark, and you said, well, I checked the Trademark Office database, which you can do online, and you said 5280, it's not available. No one's used it. It's not registered for publications. I'll file an application. So you could do that, using that as an example, and the Trademark Office examiner would look at the office records and say, 5280, is there a 5280 for publications or anything related? Nope, there isn't. And the office would issue a registration. Well, now 5280 magazine learns about it, and they come to you and they say, you're violating our rights. And so registrant, the person who's registered, might say, well, I can't violate your rights because the Trademark Office gave me a registration. But what 5280 says to you, and this is the basis for its rights, we used it before you did, and we don't have to have a federal registration to have rights, because remember when I first talked, I said you don't have to have a registration. Your rights are based upon use. And so we want you to cancel your registration, or it has a right to file a cancellation proceeding in the Patent and Trademark Office, and it's kind of an adversary proceeding. It's kind of like going to court. It's a modified version of doing that. But many people who have products, if you have inventions, you have a product, or you have a process, and then you have a name for it. You want to distinguish your product or your process from someone else, and that's where trademarks come into play. So you can have a patent without having a trademark, because the patent is the monopoly on your invention, and so the government says you have a right to control. And if you use a name, you want to pick a name that no one else has used, because if you pick a name that somebody else has used, you may have a patent that would give you a right to stop other people from making, using, or selling. But the other person would have a basis to stop you from using the name that you use for the product that's covered by the patent. So it's lots of things. And so so a patent is an invention, a trademark is a brand name. It can be a word, it can be a slogan, it can be an image, it can be a combination of images, numbers. Yes.
In regards to that brand name, do you have to try to, or does it, when you try to multiply the scope of your brand name, for example, Coca-Cola, no, but there's plenty of cola sodas out there. So if Coca-Cola branded its name, trademarked its name as Coca-Cola, does it also have to say Coca or Cola generic? So if any other person tries to.
That's a good question. Cola is a type of product. So no one can acquire rights solely to cola because it's recognized as a product type. It's generic for a product. So Coca, in combination with cola, form a trademark. So you have RC Cola, Crown Cola, you have other colas, and they don't violate the rights of Coca-Cola because they're not using Coca with it. And Coca-Cola is an example, like 5280, which has used its product on a variety of, its mark on a variety of products and services, primarily by licensing other people, so it expands the rights that it has in the mark.
I have a question.
Sure.
If you know, we rewind time and whatever his name is, Mr. Coca-Cola, decided to say in his trademark name, you know, and look down the road and said, you know what, I'm gonna capture Pepsi, I'm gonna capture 7-Up, so I'm gonna say Coca, Pepsi, and Cola. So then down the road, when someone wanted to break up part of that to say, nah, I'm RC Cola, wait a second, it's part of my original patent or trademark.
Trademark. They could do that, yes. They
So
could have
if
done
you're
that.
coming up with a combination of names, that could potentially.
I was
be
forward
generic
thinking, but
brand.
probably at the time that Coca-Cola came out as a brand name, Pepsi-Cola wasn't around.
Right.
So there was probably no idea in the mind of whoever that person was that, well, there could be thinking
Right,
forward,
right.
there could be an RC and a Crown and all that. People do that. Actually, that's what people do with domain names.
Right.
Because they'll take a domain name and they'll take one word and they'll add, first of all, you'll take 5280. You have 5280.com. Then they probably have 5280.net, 5280.biz, and all the other endings, the top-level domain names, the generic names, so that they can preclude other people from using a domain name that has their name. So then someone will come along and use 5280-Denver, 5280.colorado.com. And so they try to go around it. The difference between a trademark and a domain name is there can only be one name at a specific spot. It's like a street address. You can only have only 1101 South Washington. There can't be 2101 South Washington. There could be a 101.5 South Washington and a 101.25 South Washington, but there cannot be more than one. That's what a domain name is in terms of the rights that you have.
And so your copyright doesn't stop anyone from creating a domain name that may parallel your copyrighted
No.
name.
No, that's right.
Right, unless you scoop them all up.
You have to use it as a trademark, and so that's a good lead into terminology, because copyright is different than a trademark and a patent. Patent covers an invention, a trademark is a brand name, a thing, and a copyright is a legal right. So there is no copyright, there's a legal right that applies to a thing. So let's talk a little bit now about copyright. It's a right that is exclusive, and there are 5 exclusive rights associated with a copyright ownership. There's the right to reproduce or copy, same right. There's a right to create a derivative work, a variation, and I'll give you examples. There's a right to publicly perform. There's a right to publicly display, and a right to publicly distribute. Okay, so the right to reproduce, what does that mean? That means if I take a book and I photocopy it, that's a reproduction. If you do that without permission of the copyright owner, which would be the author or publisher, then you violate that person's right. So if you put it on a photocopy machine and you make a copy, that's a copy. If you put it on a scanner and you scan it, that's a copy. If you hand write it out, that's a copy. If you take a photograph of it, that's a copy. So the right to reproduce is pretty broad in terms, it's not limited just to one specific type of copy. In any way you can duplicate something, literally, that's a violation of copyright. Okay, that's an important right. And that's the right that probably there's two other rights. That right may be the one that's violated most. The next right, it's not necessarily in order, is the right to create a derivative work. And that comes into play for people who create books, art, photographs, because you take, let's take a book as an example. That's probably a good way to get into this. If you take a book and you write a screenplay based upon a book, the screenplay is a derivative. It's a variation of the copyright that applies to the book, and only the copyright owner has a right to create a screenplay.
Question. That copyright variation also protects you in different mediums. For example, if you made it in, let's say, paper, but someone copied it on plastic, you're still covered because even though you copied the information on a different type of material.
That's right. So that was a scanning photocopy.
Right,
Yeah.
so even if you reprint it on plastic, say, hey, I put it on plastic, that's erasable,
Right.
it's not copied,
That's right.
technically. Or, so how about the design? They say, for example, that fixture there that holds the
Okay.
lights,
Mhm.
let's say you're the first one that came up with that, and you drew that and say, I want to make millions of those, and you filed copyright on that design, can anybody else produce that?
They
If
could
you
produce it
physically
without,
created it.
I think what you're saying is, can anyone else produce it without violating the rights of the copyright?
Right.
It depends upon the subject matter of the design. So the person who does a sketch, and we'll take that as an example of creating a derivative work. An artist sketches out this candelabra. So there's a copyright for the sketch. So if somebody photocopied, hand copied, photographed that sketch, that's a violation of a right to reproduce. Now, if that person then went to a foundry or a sculptor and said, here's a sketch for my candelabra, can you create a candelabra? If a person did that without permission of the copyright owner of the sketch, they would violate that person's rights because that's a three-dimensional version of the two-dimensional object.
Good.
So the Walt Disney characters initially were cartoon characters, and they made soft sculptures and plastic sculptures and a wide variety of products. Those are all derivative works, and they need permission from the owner of the underlying work.
So that would be like, I have the drawing you're making, it's like the original drawing, it's just a flat 2D,
Yes,
right? And so that's a visual arts, right?
yes,
And then I have Mickey Mouse as a 3D stuffed toy here, whatever. And that's the sculpture.
yes.
And so the sculpture is a derivative, right,
Of the two-dimensional,
of the visual.
right. Or it could be reversed. You create a sculpture, and someone then takes a photograph of it. Right, exactly, two-dimensional. That's right. That's right. I'll go back there and I'll come here.
I'm sitting here watching, and I know Roger's broadcasting you
Sure.
through the internet, and if he makes copies of this, and then he says, okay, I'm gonna put these all together and make it so that all the members can purchase one for, $30.
Mhm.
How does that work?
Well, probably what Roger would have done is he would have me sign a release giving permission to use not what I'm saying, because yes and no. He needs to get my permission because I have what's called a right of publicity, a right of privacy. A right of publicity is another type of legal right. It's the right of celebrities and individuals to benefit commercially from their image, their name, their likeness, anything that's their persona, anything that's associated with them. So, and a right of privacy is the right to be left alone. So it's kind of just the opposite. Publicity is the benefit, and privacy is to kind of stay out of the limelight. In New York, they call the right of privacy, it's equivalent to the right of publicity. So what Roger would do with the speakers, he'd have the speaker sign a release, and the speaker would say, yes, I agree that you can take images of me, record what I'm saying, And then what Roger would like to do is he'd like to have ownership of what I've said, okay, whatever is embodied in the video, because then he becomes a copyright owner. So I may be creating it, but if I'm talking extemporaneously as now, and I don't have a script, I have no copyright in what I'm saying. The way that a copyright comes into being with respect to what I'm saying now is by recording it. So when you take something and you record it in what's called a tangible medium of expression that lasts for more than a few moments, there's a copyright. So if I'm on live television and it's not being recorded, there's no copyright. If you go to a baseball game and then you watch baseball on TV, or if you watch baseball on TV and you hear an announcement that says, this program is protected by copyright, no one may reproduce or copy or publicly reform, because what they do is they videotape or film the baseball game at the time it's performed, because otherwise there's no legal protection for the game itself. But the way they get legal rights applicable to the game is they film it. And once they do that, it's now in a tangible medium of expression. Someone makes a duplicate of that video or film, they violate the copyright owner's rights. So if Roger did that, then he has a copyright. If I transfer my rights to him, we agree, then he owns the copyright and he can put it into a CD, a DVD, he can do it in audio tapes, he can do it on thumb drives, whatever means he has to reproduce it or embody it into something tangible, and then he sells it. And then if you receive a copy and you make a copy and give it away to a person, that's a violation of copyright. Even though that's right, of Roger's copyright. So what does Roger need to do to have the copyright? Well, what he needs to do is just put it into something tangible that's recorded. The copyright lasts. How long does it last? Well, if Roger is creating the copyrightable content, unlike a patent, copyright lasts for a long, long time. It lasts for the life of the creator under the circumstances, who the creator is, plus 70 years.
Plus
70 years.
7.
70.
Oh, 70.
70, yeah. So unlike a patent, which is country by country, so if you get a patent issued by the United States Patent and Trademark Office, the rights that you have are limited to the United States. So if someone were to take that patented invention and understand how to make it and go to Canada and reproduce it in Canada, there's no violation of your patent, because it's the patent owner needs to go to each country with some exceptions to get a patent, so it needs to be separately granted. There's some treaties, international treaties, there's a patent cooperation treaty where you can get a patent and have the patent be effective in a number of countries who are signatory to this treaty. But otherwise, country by country. Trademark, same type thing. If you use a brand name in the United States, the rights that you have are limited to the United States. So if someone in Canada says, well, that's a great product, I'm going to name it the same thing and sell it in Canada. The US trademark owner doesn't have a basis to challenge, if there's no rights in Canada, to challenge in Canada. Okay, copyright, different. If you have a copy, the trademark owner needs to do something in Canada also, and if you have a patent, you have to do something, you have to get a patent to be able to challenge. With a copyright, that's not the case. With a copyright, you have a copyright in the United States simply by creating something that's protectable. That's all. So people say, how much does it cost to get a copyright? What do I have to do? I say, the cost of a copyright is the time and effort and money you spend to create what you're creating. So if you're taking notes now, you have a copyright in those notes, and it lasts your life plus 70 years. You don't have to do anything more. And the rights that you have, you can enforce in about 150 other countries, simply by virtue of an international treaty. What the international treaty says is, you are entitled to what's called national treatment. That means you would receive protection in Germany for your copyrighted notes to the same extent that a German national receives protection. So they put you into the shoes of a German national and say, what would that person receive? That's what you get in Germany. So you don't necessarily have the exact same rights you have in the US. You're limited as to what those rights and how they're enforced in that country. But from a copyright standpoint, it's pretty universal. There's a lot of similarities, so they're not as it is with patents. There's some more limitations on patents as what can be protected, but copyright is pretty much the same in terms of the rights, the life of protection. In most countries, you don't have to register a copyright. In the United States, you do not have to register a copyright. People register copyrights because there's some benefits. So people usually come in, again, on terminology, they say, I want to trademark my projector here, and I want to copyright the name for it, and I'm going to get a patent for the content. And I kind of say, well, no, really what you want to do is you want to get a patent for the process or the mechanism of electronics in the projector, and you want to get a trademark for the brand of the projector, and you use, a copyright wouldn't apply to the projector itself, but it would apply to photographs of the projector, promotional literature. So copyright comes into play for businesses in many respects for promotional literature. Advertising, websites are protected by copyright. And going back to how do you get it? You create, lasts for life plus 50. So then the question is, do you register? Yes, there are benefits, but it's not required. Yes.
Staying with the same topic, and so this one has 1, 2, 3, 6, 9, let's say it has 10 arms. Would a variation of that, could I still get protection if someone just decided to put 2 more on there? 2 more arms?
Arguably you could. The test for copyright infringement is substantial similarity. So if it's substantially similar, so adding 2 arms to that candelabra, it's going to probably be substantially similar. So that would be a copyright violation. So let's talk, again, I'm kind of bouncing around, and maybe I'll bring it all together at the end. But to get protection for copyright, you can register with the Copyright Office by depositing a photograph or a piece of sculpture, pay $55, you get a registration. Now you have a registered copyright. So to enforce that copyright, somebody else comes out with a sculpture like that, okay, another candelabra, and you say, oh, wait, looks just like mine, violated the copyright. There's one other thing you have to prove. You have to have access, an opportunity to copy. So if you created this, got a copyright, and I never saw that, and I created the same thing, there's no copyright infringement, unlike a patent. So a person doesn't have to know that you have a patent on a device. If it's covered by, if your invention's covered by a patent, and they create the same invention, it doesn't have to be intent. They violated your rights. Copyright, you have to prove substantial similarity and access. And then you can go a little bit further and you say substantial similarity, but when you have common objects, there's going to be more of a likelihood that things are going to look alike. So if you take a photograph of the mountains, a mountain scene, and I do too, we're both going to have a picture of a mountain scene, right?
Right.
So if mine looks like yours, did I copy your mountain or did you copy mine? Well, it's common subject matter, so I'm going to have a little bit more difficult, as you would have if you were trying to challenge me to say, wait a minute, David had access because mine was in the Denver Post on the front page for 5 weeks, and now we go point by point. His mountains are going to look just like mine. The coloration is the same. So it's a matter of proof in terms of proving infringement, of showing infringement. Yes.
Let's say Roger walks down the street, I take a picture of him, I turn around and put that in 5280 magazine, they pay me $10,000 to take a picture of Roger, but Roger goes, I didn't okay the ability for this to happen. How can he protect himself?
He sues you for violating his right of publicity.
But then you also have paparazzi out there that takes photographs. Okay.
So there's,
Do I really have a right of publicity and
Yeah.
not well-known?
yeah, you do. That's why, yes, you do.
So in this
Well,
one-
especially when they're using it in a commercial way. They're using your image of you in a
Because,
commercial way.
like my privacy, if I'm walking on the sidewalk on the street, I don't have a right to privacy there.
Right, you're a public place, but you have a right of publicity, so that's the other side of it. So that's why in motion pictures, with respect to TV productions, they always have what are called talent releases. They have everybody who participates in the production sign a release. I wrote a book years ago. It was called How to Protect Your Creative Work. It's a book on copyright protection. And about 8 years ago, I got a call from a motion picture production studio in California. and they wanted permission from me to use the cover of the book in a motion picture. They didn't use it, but they asked for it, and I said, sure, that's fine. The motion picture was the story of the man who invented the intermittent windshield wiper. Do you remember that? Yeah. Uh-huh.
I saw that.
Yeah, they were going to use the book in that to basically talk about, because it was all about intellectual property rights, remember? He had these rights and they never acknowledged his rights. So there's an example of, I owned a copyright, and so they were very prudent and very cautious to get releases, and that's what they do. So if there's a filming somewhere, generally they'll try to limit the people who go into the filming area to have people sign releases, because they do not want to be sued for a right of publicity. Even if they have a good case, it's a pain to be able to defend that regardless. And many people make claims simply thinking that because they've made a claim they're going to be successful, but these companies are so accustomed to being right. Yeah.
Follow-up question, so if you have multiple designs, like say if you were an artist and you were creating different kind of pictures, you would copyright each one, every variation to give you as most protection from someone
Okay, you're right.
duplicating that.
Yes.
that
Right. And so I'm going to help you here in terms of you would copyright everyone. You don't have to copyright everyone. You just have to create, because the copyright's an automatic.
Oh, yeah.
Remember?
I would create, right, so I would have to create every version. So I look at.
But even if you created every version, and one of those every versions was produced by someone else who never saw your version, there's no copyright infringement.
But if you were promoting that version, let's say your product is out there and you have these different variations, like let's say for example Lego, and they create castles,
Right.
So to keep other people from creating a Lego castle the way they did it, that they created it, took a picture of it, and they achieved a copyright.
That's right. But copyright doesn't protect the idea. It only protects what's called the expression of the idea. That candelabra, how it looks, that Lego toy. So
Right.
someone else can see your image of a Lego toy, and if they reproduce it, and if they reproduce it without, it doesn't give you the right to prevent someone from reproducing that toy. It just gives you the right from them copying the toy. So if they copy the photograph, that's a copyright infringement. So copyright is, in a way, it's broader than patent. It's less costly to get than a patent, and it has a wider area of legal protection because, as I say, it's international in scope. And unlike a patent, as with a trademark, you don't have to do any registration to have the rights. So when you have third parties, so you're creating a website. So a client comes in and the client says, I've got this wonderful website, and here's the process. I'm selling a product, and I want to promote my product on the website. And the product that I have is the shape of, it's a stuffed toy, let's say an animal, a cartoon character. So the client says, what are my legal rights? What do I have that I can legally protect? And people want to know, because they want to know, how can I keep someone else from doing what I've done? So we look at the soft sculpture, and I would say to the client, well, did you create this? And the client said, well, no, I had a really good friend, and that person was a seamstress, and what I did is I told them, I wanted you to create this rabbit-looking soft sculpture toy, because I have a name for it, and I want you to create it for me, and I'll pay you, or I won't pay you. And so what the client doesn't realize is having someone else create doesn't give that client the rights. Even if the person who created the seamstress or the sculptors created it and gives it to the client for a fee, that person owns the copyright, because under copyright law, it's the person who creates, not the person whose idea. Okay, now we're going to vary this. I have an idea for a soft sculpture toy. What I do is I sketch it out, okay? And now I give it to someone who has the ability to make soft sculpture. So when I give the two-dimensional sketch to that person, they're creating what? A derivative work. It's three-dimensional. It's my copyright, even though this person created. That person would violate my copyright if I didn't give permission. So I own the copyright, not that person. So many people, when they hire graphic artists to create websites, they think, well, I'll pay the graphic artist and I own the rights, and they don't. And often, that's sufficient. The graphic artist or the website designer is happy to get paid, and they walk away and everybody's fine. But sometimes people have second thoughts, and they say, well, you know, that was a great design. I want to use it for someone else. And by the way, I own the copyright. You don't own the copyright. You can use it on your website, but you don't own the copyright. Yes.
Several years ago, I hired a caricature artist to create a creature for me, so I can use that as a icon for my business. If I said I paid him to do that, say I paid him $100 to do that, then am I the owner of this copyright? And then, do I have to pay him anytime, like if I was to make the soft sculpture out of them, or if I made a animation movie out of with him and such, do I have to pay him for creating that, which I already paid him the one-time fee to do that?
Well, we'll start from the idea that whoever creates is the copyright owner, okay? An exception would be an employee who creates within the scope of employment. So if the graphic artist or the artist was your employee, and within that person's scope of employment was to create art, whether you paid a salary or you didn't pay a salary, you own the copyright. The employer automatically owns the copyright. But outside that context, if there's not an employee-employer relationship, then the person who creates is the copyright owner initially, unless you gave that person a sketch. But in your example, we'll say you didn't. And you said, I have an idea for this really great character, cartoon character, or whatever. Here's $100 or $50 or whatever. And that person created, what you got was a sketch, a piece of tangible material. You got a drawing, a piece of paper or whatever it was put on. That's what you got. You didn't get the copyright. The artist owns the copyright, notwithstanding that you paid for it. That does not transfer rights. The way rights are transferred is that person, if not your employee, needs to sign a document that transfers rights. It's called an assignment or a transfer document. And if they did that, then you now own the copyright. Okay. Remember I said copyright lasts for life plus 70? Well, whose life does it last for? Yours or the graphic artist? It lasts for the life of the creator, other than when the creator's an employee. So it's life plus 70.
So that means that me as a wedding photographer, I go and I photograph a wedding. I create 500 images while I'm at that wedding.
You own the copyright.
Every one of those, even though I'm being
As long
paid.
as you're not an employee, but an independent.
Right. That's exactly right. You own.
I'm being paid by my client to
Right.
create those images. I'm the owner of those copyrights.
That's right.
So that means that anytime they make a copy of my pictures, they're infringing on my copyright.
Technically speaking, yes. And in
So
the past,
isn't there like an implied license?
there
Or
may be an
is
implied
the
license to
client
use,
free
not to make copies though, because that's how, in the past, photographers now, if I'm correct, understanding it, photographers earn money for the fee they charge, for the services they provide. And then they also sell copies of the images. But many photographers say, you know what, you pay me $500, I'll take pictures of your wedding, and I'll give you the digital format. You can
Yeah,
make
you
as many
can
copies.
override it with an agreement, I mean, if you're smart, because you probably want to clarify that owns, because there's a lot of confusion.
Right.
People don't see anything.
It's not,
They think that they're paying someone to do the work,
Yeah.
they own it, but
that,
they don't.
that's,
And
that's,
then on top of that, if I use those images from that wedding in publications for marketing purposes, do I have to pay them for that?
well, you have to be careful because it depends upon how you use it. If you use it for marketing purposes to promote your business, it's the degree of your use that's going to determine whether you're liable. If you're now selling copies of the images of a bride and groom on a poster and they're for sale at Walmart or wherever else or on the internet, you're violating their right of publicity. You may own the copyright, but you don't own the right of publicity. So Elvis Presley, the photographer who took pictures of Elvis Presley, made those images available to other people. And other people use the images saying, well, we got them from the photographer. And Elvis Presley's estate said, no,
So
no,
if
that's,
I'm the
I have a right.
photographer of Elvis Presley, and I use those pictures in my advertising, but I don't sell the pictures per se.
Right.
Okay.
you're probably okay. There's a difference between technical okay and practical okay, okay? You could violate someone's legal rights, but the reality is you're not gonna be sued because of the downside, meaning how much it costs and the effort you have to go through for people to sue, so you don't get sued. Because you're low key, you're tolerable, okay? But technically, you can violate someone's rights, and they could sue you. They have a basis to sue, but litigation is another thing that we can talk about, or you'll have another conversation about that. Because notwithstanding that you have legal rights, many people don't enforce their rights because it's very costly to do that. So you have to balance, how much am I being hurt versus how much is it gonna cost me to not be hurt? Is it gonna be a wash? Am I gonna spend all my money in a lawsuit and recoup that money and be even, but have gone through a year or year and a half worth of pain? Or am I gonna come out positive? Or is it a matter of principle to me? Do I sue simply because they're not gonna get away with it? And people who do that, who sue on that basis, usually stop about halfway through or 3/4 because they start realizing how much it's costing for the principle, and they in the end they say, wow, why did we do that? Years ago I represented Cliff's Notes, and Cliff's Notes had the yellow and black Cliff Notes. It was and Doubleday came out with a product called Spy Notes, yellow and black cover, and it was a spoof on Cliff Notes. And Cliff Notes said, you know what, they're violating our trademark, the black and white diagonal, black and yellow stripes. That's our trademark, and their book looks just like ours, and we'll sue them. And they did. We went to court in New York. This is probably 20 years ago or more, and we got a judgment in our favor. But then it was appealed by Doubleday, and the federal court, the appellate court, said it was what was called fair use. It was okay. It was a parody. So basically, we went through an exercise, and the client afterwards, I'm telling you this because the client afterwards said, why did we sue them? After they spent, at that time, over $120,000 on attorney fees in New York. And they said, they went out of business. It wouldn't have hurt us. So people need to evaluate how much are you being hurt, how long is the hurt gonna last, can you tolerate it, and how much is it gonna cost to remedy the hurt. Yes.
Follow up like Elvis's estate. So I own the copyright, but since I'm gonna be dead pretty soon, I can transfer my copyrights to an estate or an organization?
Yes. And it's really important that people who do estate planning, attorneys or other people who have to recognize that we all have copyright ownership for a variety of things, because throughout our lives we create a high percentage of items that are protected by copyright, but we never focus on them. Those are legal rights. They're what are called intangible legal rights, assets that you have. So if you have copyrightable content, photographs, music, books, art that you've created, that all has value. And so in a will, people should go through what they've created with an attorney and say, you know, I have this right, and I want this right to go to this person. Because if there's no specification, there's no bequest of a specific item, and it's not mentioned, there's something in a will, it's called the residuary estate, the residue, what's left over. And so everything else that hasn't been specifically bequeathed goes into the residuary estate, and whoever gets the residuary estate may get the value of that person's intellectual property from a copyright standpoint.
So the artist known as Prince just passed away.
Yes.
As I understand, he didn't have a formal will. And now his half-sister and a bunch of other half people are trying to, his full sister and a bunch of other half siblings are trying to go after the estate. My question is, I guess twofold. One, they're able to perhaps fight for his estate. But then, like, as another artist, are we allowed to now play his music and record his music and then sell it? And
Yeah, you have a lot of good questions, and they come up every day.
That's the tricky part of like inheriting intellectual property, because it's property, but it's not like real estate, because intellectual property has to be managed and worked
Yeah.
to be a business and be profitable. Like someone inherits a patent, but unless they make it into a commercially viable business,
They have this legal right.
the right doesn't mean much.
Right. exactly. So, there, again, we can use Prince as an example. He's a songwriter. Both, I believe that Prince wrote a lot of music, right?
Oh, yeah, wow.
Okay, so when he wrote a song, who owned the copyright to the songs that Prince wrote? Who? Okay, right. And how long did the copyright last?
His lifetime was 70 years.
Right, okay. So what happens with many songwriters, they don't have the means to get the song recorded or out commercially. So what songwriters, and Prince was that way initially, and he evolved into where he was basically a one-man business. But many songwriters want the song to be recorded. So the process is, and this is all copyright. Songwriter owns the copyright, doesn't have the means to get it out. Songwriter goes to a company called a publisher, a music publisher, and it says to the music publisher, or he or she says to the publisher, I have this song, the publisher evaluates it and says, that song's got a lot of potential. So the publisher and the songwriter enter into an agreement, a publishing agreement. And usually the publishing agreement says that the publisher will pay the songwriter 50% of the money that the publisher receives from exploiting the song. And so now the publisher owns the copyright. So Prince doesn't own the copyright anymore, initially. And so the publisher then markets the song, and it's made into now CDs or DVDs. And every CD or every recording of it, once it's released, the record company, which is a separate entity, maybe part of the same group, now needs to get permission to reproduce that song, because remember, now it's just on sheet music or notated. So they need to get permission to create a variation, a performance of the song. Well, who do they have do that? They have recording artists. Prince is a recording artist. So the recording artist usually is signed to the recording company. The recording company says, whatever you create from a copyright standpoint, your recordings, your performance, we'll own that, and we'll pay you a percentage of money we get for every record or DVD or CD now that's sold. And the recording company pays the publisher a fee for the right to reproduce the song. The publisher pays Prince. So Prince is making money from recordings of the song. Okay, now the recording artist, through the record company, is now performing this song at concerts. Well, under copyright law, one of the rights of a copyright owner is the right to publicly perform. So whatever concert venue there is needs to pay for the right to publicly perform. So money comes in, eventually to Prince, from the nightclub, Red Rocks, television stations, radio stations, department stores, churches, wherever music is publicly performed, they need to pay a fee because of violation of copyright. Without it, the fee gets the license. Money comes in, part of it goes not to the record company because they're out of the picture. They're making money only on the CDs. The money goes to the publisher because the publisher now owns the copyright, and one of the rights is the right to publicly perform. Prince gets money from the CDs and gets money from the public performance. Now Prince can also join, there are three major public performance organizations that go out and license. One's called ASCAP, American Society of Authors and Composers, another's BMI, Broadcast Music, another's called CSAC, S-A-C, I think it's the Stage European Composers, don't remember exactly. And they go around to clubs everywhere and they knock on the door and they say, well, you're performing music here. Yeah, we have a band that comes in and does that. Well, you need to have permission to do that. Yeah, but the band plays music. Yes, but you have control over the nightclub. You need to have a license to be able to do that. And after some persuasion or after being sued and learning that they have to take a license, they take a license and they pay for that. And so now Prince is making money from CDs, he's making money from publishing. If it's used for soundtracks of movies, that's synchronization, that's a reproduction in a different way. He makes money that way. So Prince has all these rights, and what happened is, the likelihood is Prince initially was an individual who had no major leverage from a business standpoint, and he grew in popularity, started earning a lot of money. He got a business manager, he had a personal manager, and they started saying, this contract is going to run out here in Morocco, and you need to start dealing with me. These are my conditions. And so probably a lot of those rights reverted or went back into his company. So when he died, he he didn't own the copyright, because probably what happened is that copyright was transferred to these companies. I don't want to get more there's a limitation on how long that transfer can last. But that's what he did. So if he owns stock in the company and his sister and brother, half brother and half sister, they're suing him and he doesn't have an estate, there's something called, in every state, it's the law of intestacy. When you die with a will, you're a testator, you die with a will. That's testacy. And without a will, it's intestacy. Well, when you have a will, you look at the will and you see, what does the will say? The will says, this is how things are going to go. When you die without a will, intestate, you look at the statute of the state, and the statute says, this is how things are going to go. So it has a hierarchy. It says if you die and you're married, everything you have can go to your wife, and then part to your children. If you don't have a wife, it can go to your children. If you don't have a wife or children, it can go to your brother or sister, it can go to your aunt, uncle, it can go to your parents. It goes all over the place, and that's how they trace who has a right to receive assets that are owned by a person who's died.
Okay, next question then, following up that.
All right.
If a
That's a
DJ,
good loop. That was a good loop.
if a DJ goes into, let's say, a wedding, and they're playing the music, they purchase the music on CD or download, whatever. They go in, they've been hired by the bride and groom to play the music.
Right.
And then he's playing the music, but they're not charging admission for people to come into this wedding.
That's right.
So then how does this all play out legally with protection for the DJ or the
Okay.
facility or the bride and groom?
So
Business doesn't have a right to that's totally performance.
that's right. So the DJ is like a nightclub, a church, a concert venue. The DJ should have a license. What happens is probably a high percentage of DJs don't have licenses. Number one, they don't know. Or number two, they know, but no one has contacted them. So the problem that ASCAP and BMI have is they have people who have to go around and kind of look, because people don't walk up to ASCAP. You know, I'm going to be a VGA club and I'd like to have a license. Most people don't do that. Why? Most people don't know that there's a copyright, because most people don't know about a copyright. So they need to get permission. So the DJ needs to have 3 licenses. He needs to have one from ASCAP, one from BMI, and one from CZAC. And then at that wedding, he can perform it. He can perform it probably anywhere because he has a performance license. But if he doesn't have a performance license, it doesn't make any difference whether there's for-profit or not for-profit. In the past, before the law was changed years ago, it was a for-profit performance, but that's no longer. There are exceptions. Veterans organizations, the statute has a list of who is an exception with respect to the requirement to have permission.
So if the bride and groom though has their iPod full of music and they go into a facility and they just plug it in,
That's violating, that's a copyright
That if a restaurant has a CD and they're playing music over the PA, that's illegal.
That's the same. It's also illegal for, not illegal, it's just a rights violation. There's a difference between illegal and a rights violation. Sometimes they overlap. Illegal is when you have a grocery store or a nightclub and you're receiving pay-for-TV fights or whatever performances, and you haven't got a license. That's illegal because there's a federal statute that says it's an unauthorized reception of cable signals. That's illegal. But in a place where they have multiple television stations, it's public performance. And now what the motion picture industry is doing, there's a group called the Motion Picture Licensing Corporation. What they're kind of doing is the same thing that ASCAP's been doing for years. They're kind of learning who uses videos or CDs in the performance of services. Educational schools, whether they're for profit or nonprofit, they need to have permission to show those things. So they're going around and granting licenses.
so if I create a video and put it on YouTube, and a teacher says, I want to use this as a teaching tool in class, are they infringing on my copyright?
Probably not, because you probably signed up with YouTube that says you don't have the copyright.
There's terms. But without that, I think it would.
Yes, that's right. Yeah, right. That's right. So that's,
So if I post it on my own website and they took it from my own website and they put it maybe in their Facebook page or they
you're
put it in-
violating your copyright.
And, okay,
That's right.
In their Facebook page or something like that, that would be a.
That's exactly right. So have you heard of a group called Getty Images?
Yeah.
Okay. They own a huge collection of images or have rights to a lot of images. And they have programs that go through the internet and they look for these images, probably certain images, and then they add to that data bank. And they find a website that has an image, a Getty image on it. And I don't know if you've heard about this, but they'll send a letter to the website owner and they'll say, you know, you have 2 images that we don't have any record that you have permission to reproduce those, to show those. You need to pay us. They charge usually $800 or so. So when people call up and say, you know, I got a letter from Getty, what should I do? I said, negotiate. You know, because you don't want to continue going through with using it, because you'll get sued, and the likelihood is to have a registration, and you have to have a registration to sue, and if you have a registration to sue, you get a lot of remedies you wouldn't otherwise get. So copyright is, in a way, scary, because we're all stepping on someone else's rights and don't even know it. We can't feel it because we don't know they're there, but they're there. And people who recognize that their rights are being violated will go out and ask you to stop or pay money for it. And there's a high percentage of copyright infringement that occurs all the time. Years ago, Texaco was buying subscriptions to 3 or 4 scientific magazines, and they would maybe buy 3 subscriptions for the entire corporation, and they'd circulate the original magazine throughout their engineering department, whatever department. And some people would take these magazines that were circulated. Well, if there's only 1 copy and it needs to go on, what do? You make a photocopy, right? Because you may want to see it later. Well, they didn't have permission to do that, and they ultimately got sued and had to pay a huge amount of money because they were making, the scientists were making copies without paying for individual magazines. So when you have a business and you have a software program, if you have 1 program of Word, 1 copy of Word, it's only, usually they're what are called single user licenses. You can use it only on 1 computer. Well, a business maybe has 5 computers in the office. They buy 1 and they make copies. That's copyright infringement. And what software companies do is you don't own the software that you buy.
Just the right to
You get a
use
license.
it.
You get a license. There used to be called a shrink wrap license, because in the past, the way you received a copy of the program, it was in a plastic sleeve. It was shrink wrapped, and you opened it and then you were using it. But now that doesn't happen, because what's occurred is, you know, technology's changed a lot. People would get something in the mail and they would order it. Now you get a code, and the code, everything's recorded so they know how many times the copies are made, and you can't just make a copy. So I worked in Serbia. I've done a lot, I didn't tell you, I've done a lot of international work. I've worked in about 15 different countries. Back in 1997, I went to Bulgaria, and I lived in Sofia for about 6 weeks to write a new trademark law for Bulgaria, because at that time, the world was changing from a trade standpoint. You hear about trade agreements, and these countries had to have minimum requirements satisfied to be able to be members of what's called the World Trade Organization. They wanted to be members of the World Trade Organization because that meant tariffs on their products would be lower. Well, what does that mean? That means if you're in Bulgaria and you're selling Bulgarian wine, and there's a tariff on your wine where you can sell it for $1 a bottle, but when it comes to the United States, it costs $8 a bottle. Why? Because the U.S. puts $7 tax, because they want to encourage local purchase of local wine versus foreign wine. And so the idea of tariffs is to get rid of tariffs to make everybody on an even keel. So I went to Bulgaria and I did a trademark law, and then I worked a lot in the Middle East and South America and many other countries, and a lot of intellectual property rights were based upon copyright and trademark. So I've seen a lot of this, and the fact that most people, a highest percentage of people, including businessmen and many attorneys, aren't aware of patents. They don't know what a patent is, and they don't understand when their clients have these rights, the value of these rights, and so they overlook them. So you just need to be aware of it, and that's what I can tell you in that respect. I can talk more about copyright, which is where we started, and for people who invent patents, actually the patent attorney who prepares the patent, because there's a description of the invention, right? And claims. Is that something in writing? Yes. Is it written? Yes. Is it written by the patent attorney? Many times solely by the patent attorney, based upon interviews with a client. Who owns the copyright for the patent description? The attorney does. But, and from a practical standpoint, that doesn't come into play because the attorney gets paid for the fee, and really the copyright is kind of put on the side. No one even pays attention because it's important, but it's not important in that
I was always under the understanding there was no copyright right in the patent.
There's a copyright in the description. It would be no copyright in the patent if a government employee creates within the scope of employment. There's no copyright for government employee created publications.
So follow-up question on that.
Yeah.
So if you come to a patent attorney with your patent and you write the description, you know, and you write your claims, and then you and the patent attorney make some modifications to keep your right as the original copyright person, you would then take those recommendations, change it, and then resubmit it?
Well, if you work with the attorney, it would be what's called a joint work. You work. To have a joint work, it's when two or more people create something together with the intent that it be created as a whole. So from a technical, practical standpoint, yes, that would happen. But if you took your invention, you write your description, and you write the claims, and then you go to the attorney, say, here's what I have, here's my patent. The attorney looks at it and says, you know what, this has got to be changed here, this is not going to fly. Well, technically, you have the copyright, and the attorney is making modifications, and you don't object because that's what you want to happen because you want a patent, and the attorney knows what needs to be done. But if you come down to the basics, then you would have the copyright.
In that scenario, that
Yeah,
you
yeah,
made the changes,
yeah.
that,
That the attorney made the changes to what you created.
yeah, the changes to what I
But if
did.
the attorney creates and you make the changes,
Right.
it's the attorney. Architects own copyrights to drawings for the plans. Building, the design of buildings can be protected by copyright. There's a lot, it's
Because
amazing.
you created it.
It's amazing what can be protected by copyright. Poetry, photographs, everybody takes photographs. You take photographs, use a camera? Sure. You have a copyright, everything you create.
Follow-up question. So you created this building in 2D image, and then you take it to everybody that's gonna build it in
Mhm.
this 3D image. Then you put that 3D image on t-shirts, mugs, and everything like that. That protects you through all the different
Yeah.
mediums that.
On a building design, it's got to be more the functional, what copyright does and protects is functional aspects of things. So, because that kind of goes into the area of patents. If it's functional, then it's protected by patent. So this could be a design, but it's got to be somewhat artful. There's a real low threshold of what qualifies for creativity. So it's got to be more than just a simple two lines together.
Gotcha. So let me bring this last one to loop this, my thought is, so, there was that big lawsuit between Apple and Samsung, because Apple created the iPhone with the curved edges on the phone, and it wasn't a flip, it was a screen.
Uh-huh.
So then Samsung changed their flip phones and created a curved phone, candy bar shape.
Mhm.
But theirs wasn't rounded, it was at an angle. And they sued each other, and Apple won because it was too similar. So
Well-
they went on a design,
Well,
or?
now we're into another area called design patents, and they went on a design patent.
A design, so it's not a copyright.
That wasn't a copyright.
Because I would have thought,
That's a geometric shape, and a geometric shape, no copyright protection.
because I was thinking, well, what if they took a photograph of that?
Couldn't that be a sculpture?
Right, that's
Yeah,
what I
but
thought is-
I think if you file an application, there's a way to test whether you think it's creative enough to get, you file an application with the Copyright Office, and they probably write back and say there's insufficient creativity, and they wouldn't issue a copyright.
Okay, but if they took a picture of that before they sold it, you know, and they put it on a t-shirt, then they sold all their Apple phones, and now someone made a copy of that phone, but changed a little bit, I would think that's a copyright violation.
It could be. A lot of it's dependent, exactly what the facts are with respect to use.
So if you create a 3-seat chair, 1, 2, 3, and it folds and this, and it's got cup holders and, whatever like that.
That's patent.
That's
okay.
bad.
All right.
But let's say you took a picture of that,
Uh-huh.
and you created it with these beautiful colors, and you want to copyright that as an art piece.
Okay,
Can you do both?
yeah,
Okay.
because the copyright, the art piece is not functional. It's not functioning as a chair, it's functioning as an art piece.
Okay.
Yeah, like the color.
Yeah,
The color would be
yeah,
artistic,
yeah.
but
Right.
it's not really.
But so if someone then took your photograph image that they saw on the billboard and said, wow, I'm gonna make a 3-person chair,
Mhm.
even though,
If they made the 3-level chair,
Oh, 3-level
they
chair.
probably wouldn't violate the copyright because it would be functional, and there's no copyright protection for functional items. But they would
Gotcha.
violate the copyright for the image. And there's a question as to whether that would be sufficiently actionable.
Gotcha. So if you had both, if you had a 3-level chair and you filed a design patent and a functional patent,
Well, utility patent,
a utility, okay, then you could also copyright it as well, right?
you copyright the image.
The
You
image.
claim copyright, and it's like the proof of the pudding is when you go to court to enforce it. It's like a patent. Is a patent valid? You find out after you go to court.
And Apple, they design patent the screen icons.
Yeah, yeah,
Right,
I think
right.
you could probably copyright those icons.
yeah,
too.
yes, you
Well,
can. They are, yeah, they
I
are.
heard that the original iPhone had hundreds of patents tied to just that device. And it could be like.
Well, it's when they first came out with that slab phone,
Right.
the screen design, the interface was unique compared to what people use.
And when you see a device that's marked with a patent, you're really not sure
Yeah, there's
what,
one piece of it.
yeah, what the patent covers.
Yeah.
So, the first thing, it's like scary. Well, I can't do anything because it's protected by patent, but the patent may be only how this connects with that, and everything else is public domain. So there's a lot of unknown, and when you file a patent, even filing a patent, you need to get an evaluation as to whether it's patentable, number one, and number two is whether it's infringing. Because you may be able to get something, and I'm getting out of my league here, but you may be able to get a patent on something, but nonetheless, you're violating somebody else's patent. So that's correct, isn't that?
You can get a patent that does violate.
Yes, yes, that's right. So you're not home free.
It's just the way the claims are evaluated, because it's natural for people to think, well, I got a patent, I'm not infringing. But
That's not the
your
case.
patent can be infringing.
That's right.
And it's because the patent office, they evaluate your claims to the prior art. You have unique things in relation prior to the patent. But your product may still violate another
Right.
patent out there that's got some product.
Right, it violates those claims.
Because it's a different standard, we're comparing
Yeah.
two different things.
And patent litigation is very, very costly. As a trademark and copyright litigation, you can spend hundreds of thousands of dollars on a patent, millions of dollars on a patent, and the same with copyright or trademark. So when people have situations where there's a violation of rights or a believed violation of rights, you need to be practical. I think you need to be practical to evaluate, what's your objective and how much, what's your objective and what's your interest versus what's your position. Your position may be, they violate my patent, they're going to pay for it. Your interest may be, they violated my patent, but it's gonna cost so much money to do that, I can't afford to pursue a claim. So that's why you see the large companies filing patent lawsuits. And then every once in a while, you see individuals who have, like the fellow with the intermittent windshield wipers, who had something there and then decided to pursue his claim. But because it's so costly, it's a big deterrent. So the thing to remember about copyright is it covers a wide variety of things that people create, if they're non-functional, okay? And examples would be books, music, art, software, poetry, photographs, sculpture, maps, choreography, and a performance. Choreography is protected by copyright. So those are the things that could be protected, the kind of the categories. The other thing you remember about copyright is what you need to do is create, and you have a copyright. You don't need to register your copyright to have a right. You don't need to use a letter C inside of a circle to have a copyright. You have the copyright based upon what you've done. As long as there's sufficient creativity, you have a copyright. If you want to enhance the rights that you have with your copyright, you can register the copyright with the United States, the Library of Congress. It's part of Congress. And that involves filing an application, paying a government fee of $55, and you can do that online. You can go through this process and provide material. And what you do when you file an application is you submit 2 copies, or now 1 copy, of what you have. Most often you can do it electronically, so you can submit PDF files for images. And the copyright is effective as of the date you file, though it might take 2 or 3 months to get the registration. In most cases, unless there's an issue. If there's an issue, the Copyright Office will send a letter telling you, here's a problem you need to overcome, or you can't register it because there's insufficient creativity. If you have a copyright and you register the copyright before someone violates your rights, makes a copy or performs it, if they do that before you have a registration, you can go to court. First you have to register. You have to register to go to court. You can go to court, and if you're successful, you get a court order called an injunction. The judge says to the other side, you have to stop doing what you're doing. And if you can prove that the other side's made money, the profits of the infringer attributable to the infringer, you can get that money. But that usually involves people like the person who's going to come in the coming sessions to talk to you about damages, proving damages. So you have to prove what the profits are. If you have a registration before infringement, and this is the incentive to register, if you go to court and you win, the other side may have to pay your attorney fees, depending upon what the court does. But the court is in a position to make the other side pay your attorney fees. And if you can't show that the other side made profits, you have an election. You can say, yes, but I want what's called statutory damages. It's a range of money from $750, usually up to $30,000. Many times people say $150, it's out. Usually it doesn't happen. So the court can use this alternative to give you money. So that's copyright. Copyright lasts for your life. It stays with you until you transfer it in writing. So you can't give someone your copyright by saying, here's my copyright, you own it. You have to sign a document that transfers it. If you don't transfer it in your life, you can refer to it in your will that says all my copyrights belong to or go to. And that's how you can transfer copyright. And so it can last, again, for 70 years after you die, which is a long time.
So if I was to give a disc of photographs I took at a wedding to a bride and groom, without giving them a copyright release, and they went out and started making money off of the images that I created for them, I could sue them for copyright violation and damages?
You would sue them for infringement. And then part of what you would like is them to stop. That's number one, an injunction. And 2, you want some money. But before you can do that, you have to register your copyright. You have the rights. In the United States, you can't go to court without having a registration. So the United States says you have the rights, but you need to take this one step. And if you do that, then you can sue. And you can register your copyright anytime during your life. So it can be registered 25 years after you die.
Follow up on that registration. So he's recording it, it's time-stamping, I'm guessing. That makes it a copyright material. For example, what if he didn't have a timestamp, he just recorded it?
Well,
no one knows when.
Well, that's the issue, but that comes into play as to who created first and whether there was a copy. And what the argument is in that situation is someone said, I didn't copy you, I couldn't have copied you because yours was created March 1st and mine was created February 28th, so how could I have copied you? So that's why the timestamp could come into play. In the past, what people did was they said, well, I'm going to get something called a poor man's copyright. And what was that? And they would put something in an envelope and they put stamps on it, go to the post office and have it mailed to themselves. And they would say to me, well, what does that mean? I'd say, it means you're going to get some mail.
Well, I was going to ask you on the registration, foreign countries, so Asian or Asian foreign countries, do they have like a similar rule that you have to register?
No, most countries don't. No, the United States is a little bit different. The common law countries are more similar to that. But most countries, you have a copyright simply by virtue of the law.
Just by the creation.
Yeah, that's called the Berne Convention for the Protection of, okay. BERNE is the Berne Convention.
Say Germany, for instance, I wouldn't necessarily have to register it to sue for infringement.
For what? For
Copyright infringement.
you have to, yeah, in the United States, I'm sorry, in
So
Germany,
let's say you're in Germany.
no, you don't have to register.
Okay.
And if you're in a foreign, you're a foreign national, the foreign national has copyright rights in the US. Different than the US national. A US national, to be able to go to court, has to register the copyright. But if you're from Germany and someone's violating your copyright here, you do not have to have you can go to court without a registration. So it's only,
If I'm an American in Germany,
you don't have to register if you're suing in Germany.
in Germany.
But if you're a German in the US, you don't have to register. But if you're a US citizen suing in the US, you have to register. So on your example, the bride and groom that makes pictures, they violate your copyright. So many photographers have an agreement that says, this is what I'm going to do. And they give, usually, as Roger said, an implied license. But in the past, the way photographers earned money, more than just for the fee, was you had to come back to the photographer to get the prints made. And that's why they gave you proofs. They gave you proofs and they stamped everything so you couldn't reproduce it, or people would do that. They'd go, what happened years ago was people would go to a photographer, get the proofs, and they weren't marked, and they go to Walgreens or whoever else, and they'd reproduce them, and they got sued for infringement. Years ago, I had a client who wrote a book, and someone literally copied the entire book, scanned it, word for word, changed the title, changed the name of the author, and sold the book on the internet. Well, that person went to a group called Create Space, which is part of Amazon. It's a subsidiary. They have these self-publishing. In the past, to be able to get a book published, you didn't have the means to get it out, so people would go to a large publisher, and if the publisher didn't accept the manuscript, you couldn't get your book published unless you went to a printer and did it on your own. But now there's mechanisms where you can go to companies like Create Space that will print on demand. So you give them the manuscript and they print the book. When people order, they order through Amazon, and you make money and they make money. You make more money than you would make if you go to a publisher. So what Amazon did was they printed the book, and so did a number of other companies' websites, Lulu, and there's a place in Minnesota, and they were liable for copyright infringement. Why? Because they were publicly distributing. The author copied, but they were publicly distributing, and one of the rights of a copyright owner is the right to publicly distribute. So the author had a claim against those companies for publicly distributing. So copyright, again, it's not just reproducing, it's the derivative works. Donald Trump's being sued by a photographer in Denver. There's a lady by the name of Wendy Shattle, Shattil. If you do a Google, you'll see. Years ago, she took a picture of an eagle at the Denver Zoo, and it's kind of an iconic eagle. It's just the perfect setting, I guess. There are lots of pictures of images of eagles. And Trump's campaign picked it up, and they were using it on placards or billboards or posters. And she contacted Trump's campaign and said, you're violating my copyright. And they said, oh, no, it's an eagle. We can do that. Besides what? We modified it. They shadowed another eye and changed some feathers in the wing. Well, under copyright law, would that be okay?
Yeah, variation.
A variation, that's right. So there's a lawsuit in New York for that.
Do you follow the Google case? I guess they won. They were scanning like older books.
Yeah, they wanted to,
And
every,
making a small portion of it available online free, and then you have to buy the rest of it.
yeah.
So I guess that was okay.
Well, what happened is Google decided it was going to get every book in the world as part of their library.
Right.
And the publishers, of course, objected to that. And they said, we're doing a public service because we're collecting all this data. So I think it violates rights, and that was part of the lawsuit. It's making a copy.
To follow up with that, so if you have a copyright they change the language in another country, you still get
Because what is that? When you
a
change,
variation.
right, it's a derivative word.
Even though it's a different language, it's
It's
still.
still the same word. That's a derivative. It derives from.
That's more like a screenplay of a book is a derivative.
Right, exactly.
And
So,
a movie is another.
absolutely, yeah. So there was a author here in Denver, his named Marco Masick. He was a writer for the Post, and he wrote a book, The Big Year. It was about birders. Apparently, if you're a birder, if you're very interested in birds, you decide you're going to have a big year, and the big year is you're going to go out and see as many birds from everywhere as you can. And there's kind of I guess it happens every year, but people don't necessarily know who's they're competing with. And this book was about 3 men who had a big year, and he wrote the book, and there was a screenplay based on it, and there was a movie that came out maybe 2 years ago. So, yes, copyright is really powerful in terms of being able to benefit from a legal right, and sometimes,
If you look at a lot of copyrights, they're more valuable than patents.
yeah, because there's
Well, because of the long life.
long life and less effort going into what,
Yeah.
you don't have to have a disclosure, a description, or an approval of whether it meets the standard or not. With a patent, you have this big hurdle and a cost to get to a point where the government agrees that it's inventive and you're entitled to this monopoly. So, to have a patent for many people it's a nice thing to have, but from a practical standpoint, you wonder how many people have patents that eventually, and Roger may have some statistics on that, I'm not sure, how many patents end up being viable in terms of generating income. We only hear, not only, but we hear mostly about those who are very successful.
There's, if Coca-Cola is in English, and they'll say that there's like a Japanese version of
Uh-huh.
it, and they translate it, is that an infringement?
Yes, it's an equivalent.
Okay, so they would have, Coca-Cola would not have to go out and register their name in Japan.
Yes, they would.
Okay.
Okay, because I've given you some information that kind of, in a way, it's not misleading, but it's not full. In the United States, the way that you have rights is to use, in the United States, in the common law countries, England, Scotland, Ireland, Australia, New Zealand, India, the common law countries, Canada, the rights are based upon use. But we're a minority. The rest of the world says rights are based upon registration. So if Coca-Cola didn't register its trademark in Japan, it's possible that someone could register the trademark in Japan and stop Coca-Cola from selling its product there. Coca-Cola would be somewhat of an exception because it's so well known worldwide, but I can assure you Coca-Cola has multiple registrations in Japan. Years ago, when the Olympics were in Spain, someone had registered Nike. I believe it was Nike was the mark. And Nike did not have a registration in South Africa or in Spain. Where was it? Spain. So they were able to keep Nike out. They ultimately resolved it. Years ago in the 1960s, there was I don't know if he was a medical doctor or he just had a PhD, but what he did is he went to many countries and he registered trademarks for, it's like, I'll get to this, it's like what happened with domain names. He registered these trademarks for these large companies, ExxonMobil, Texaco, and when these companies got around to recognizing, gee, we need to register our trademarks to have rights because we don't have registration, we don't have rights. He basically said, well, you want my trademark, it's going to cost you $50,000 here and $50,000 there. And so he was able to do that. Well, something similar happened years ago when domain names became very popular. What some people did is they went out and registered domain names before large companies got wind of this is something they should do. And then what they did is they started saying, well, if you want the domain name, you got to buy it. And it was very profitable for a group of people who did that, selling domain names. And that still happens now, but not on the same scale. So sometimes you go to websites, you'll see this site's being held, and if you want to buy the domain name, you can buy it. So domain names are kind of like copyrights, but you have to register. Copyrights, you don't have to register. Copyright's very simple to have a right. Trademarks, same thing, you don't have to register. The difference between trademark protection and copyright protection is the rights in the trademark are where your product is known, where you have a reputation. So if you use a trademark in Colorado, but you don't use it in Texas or Washington, D.C. or Oregon, you don't have rights there. In the past, that was how things worked. But now, because of the internet, people who sell products in Colorado, they probably put it on the internet. And so their argument is they have rights everywhere where the internet is, and therefore anyone who subsequently uses it violates their rights. I worked for General Foods a long time ago, and at that time, what General Foods would do is they'd have a name for a new product. So what they'd sticker a bunch of, they'd take 2 cases of the product, an existing product, and they'd sticker those products with the name for the new mark, and they'd drop them off at different stores. So they'd have, because they had a use, they could say, we have a use. And then they'd have someone go around and pick up the product. But that was how they were able to establish rights.
In each state?
In each state.
Oh my gosh.
Yeah.
Well, of course they were for it.
Yeah, they were, that's true. Years ago, I represented a company that made perfume. It was called Joy. Joy, at the time, was called the most expensive perfume in the world. It was called Jean Pateau. I worked for Borden. It was one of the subsidiaries. And Jean Pateau had a competitor in France. And the competitor's trademark, it was a competitive product too. It was called Snob. So what Joy did, Jean Pateau did, is they registered Snob with the Patent and Trademark Office in Washington, D.C. before the people who owned Snob did. And when Snob, they tried to bring the product into the country, Jean Pateau had deposited, you can take your trademark registration, you can do this with copyright registration, they deposited it with U.S. Customs. And Snob couldn't get its product into the country because the customs blocked it. They blocked importation. That was a strategy. If you have a copyright, you can register your copyright. You can deposit a copy of your registration with U.S. Customs and use that as a way to bar importation of products that are infringing. So that's a value. It's $180 to do it, so it's pretty significant value or benefit for the small amount of money you pay. So that's an incentive to register your copyright. So if you have a copyright, do you, as a photographer, you have hundreds and hundreds of pictures. Do you register every picture? It becomes costly, $55 each. So what some photographers do is they take contact sheets and they register 200. So that's only one work. Each image is a separate work, but from a copyright registration standpoint, it's compilation, yeah. Years ago, I represented some women who were teachers, and they created monthly guides for children, elementary school children. And they had the foresight to register the copyright for each monthly edition of their newsletter. And then what they did is they took the newsletter and they compiled the newsletter into a book that they could then sell to teachers. So they had 12 copyrights, plus they had 13 because they had one for the book itself. And there was a group in Michigan that copied the book, substantially all the book, enough to be an infringement. And by the time that the teachers learned about the infringement, it was close to the time that the competitive book was the sales were waning, so there weren't a lot of profits any longer. And so the attorneys for the Michigan infringer said, well, it's only one book, and if you sue our client, the profits are really small. You're not going to get any money. It doesn't make sense. We said, we have 12 infringements because they're 12 separate works. So it multiplied what was called the statutory damages. So there was a situation where it paid off for these people to register their copyright. High percentage of people don't register copyrights because they don't know about it. They don't know the process. It's not complicated. And it's inexpensive relative to a patent. It's even inexpensive relative to a trademark. Trademark, the government fee is $275 for one mark in one, what's called class. Yeah, plus renewals. Those come 5 years. No, there used to be a renewal. The law changed.
So
Yeah.
Nike, if they wanted to
Yes. Well, shoes, it's a class, it's class 25, clothing, so it depends upon what the article called, headgear, footwear, they all go in one class. But if Nike had
So they would go in one class?
Now they have golf clubs.
golf items would be sporting goods, that's a separate class.
Okay.
If they had publications, they had pamphlets, scorecards, that's another class,
And how many classifications are there?
44.
44.
Most of them are what are called goods or products, the other for services. So entertainment services, bar and restaurant services, those are different classes. Music performance services, educational services, it's another class, 2 different classes, 3 different classes.
Did you see that deal? It's kind of a pretty decent copyright to block revenge porn.
No, I didn't see that.
Revenge what?
Revenge porn. So, let's say a couple's in a relationship and there's some topless pictures of the woman, and then they break up, and then the guy's posting the pictures online, and she doesn't want them online. So I think it was a deal of she got those photos copyrighted and then sued him.
It's registered the copyright.
And to get him to injunct
Mm.
to
Stop.
take the pictures
Yeah,
down.
yeah.
It was like a very effective way to stop that. But I guess you'd also have a right of publicity.
Both, yeah.
So let's walk us through this. So what she did then is she had to take another picture of herself naked because she didn't have the originals, and then register that because let's
Well,
say.
she could have gotten the ones that he had. The
Oh.
question is, it was probably resolved based upon what you were saying, but the question would be ownership, who owned the copyright? Was it a joint work, we created it together, or was it a single work? So that's an issue you have to resolve, as to who is the owner. And many times that becomes a question, is who is the owner? Who has the right to bring an
Yeah, if
action?
she took a picture of herself, then, okay.
Then,
But if he took a picture with his camera.
then he owns the copyright, the photographer, but she has the
but
right of publicity.
of it,
Right.
he has to get her.
Right, permission,
Okay,
so,
wow, a lot of stuff.
yeah, there's a lot of stuff.
So how do we use you? I mean, as we,
Come to these programs.
as we move forward, with copywriting information.
I'll give you a card, you can go to my website and it tells you more about what I do and
Okay.
all that. There's information on there about, mostly about trademark.
Sometimes like permissions can get kind of complicated.
Yep,
If you don't wanna, politicians do this all the time, right? They're just using anybody's music willy-nilly.
Yeah.
And they
there,
where people make a big deal and they put, oh, this song fits perfectly, what do you care?
there have been cases there where someone in a parade used music that were sued by a band for using the band's music, so, yeah.
The Stones are suing Trump.
Yeah.
Because Trump is usually starting to
Yeah,
get
yeah. Yeah, so
Okay.
there's a lot of, I'll say, innocent infringement, innocent in the sense that people aren't aware that what they're doing is violating rights, because we're so accustomed to seeing things out there, and the common response is when you say you're using someone's materials, well, it's on the internet. Why would they put it on the internet if we couldn't use it? Well, that isn't the case. And so that's part of the controversy, and there's a lot of talk about copyright being too broad in terms of giving rights in the market today, and what's happening, how technology has changed everything, that many things are so accessible easily that weren't that way in the past. Now, I guess my example was, in the past, if you had a book and somebody infringed the book, the likelihood is they didn't type a copy because that took long. So they put it on a photocopy machine and they photocopied it, okay? So that was a way to do that. But then you had to make photocopies, and however many photocopies it would take and how long. And then along came scanners, so you could scan it. But even with the copies that you made photocopy-wise, you had to hand it to someone or mail it or in some way deliver it to someone. So when you scanned it, it was faster because the technology allowed scanning, and you could now distribute it. You didn't have to be face-to-face, you could distribute it through the internet. And now there's devices that scan rapidly, and you can distribute it instantaneously throughout the world. It's just like that. participated in a program in Jakarta years ago, and I had written a book on copyright, and it was a USAID program, and they wanted to have copies of the book to hand out at the program. And the publisher said that was fine, and it was amazing. They made copies of the book, and just the technology they had, and I guess the cost was, if you had to do it in the US, it would be too costly, but they did it within a matter of days. I was amazed. I thought, you're never going to be able to do that. They did.
So if I'm sitting in, like watching a football game, and my friend decides that she wants to get a picture of all of us that's in this group, and she wants to post that photograph on Facebook,
Mm-hmm.
how do I protect myself from online being, because many times I find myself like going like this, because I hate my picture being taken in the first place, so I have a photographer, I'm a behind the scenes kind of guy, but it's like, it's like CNN would always put these pictures on Facebook, and I hate, having myself out there. So what can be done?
You claim you're violating your right of publicity. That she'll claim that you have all these technically correct ways to enforce rights, but from a practical standpoint, the difficulty of doing is so great that it's a deterrent that you wouldn't do anything other than complain. So I kind of use different analogies.
I mean,
I
if
guess.
you think about Facebook, it's like, it's this huge, intellectual property rights violation.
Oh yeah,
Cool.
and there's something else that I'm glad you brought that up about Facebook, because everybody here, or many people, use the internet. A high percentage of people use the internet, right? And you go to websites and they have click, do I agree or disagree? So how many of those agrees before you agree do you read what it says?
It's 38 pages.
Yeah. And it says, and if there's any dispute about this, you're going to arbitrate in Florida at 12 o'clock at night, and you're going to pay for all the costs of the arbitration, and if you lose, you'll give us your house and all of your jewelry and everything. They're unconscionable contracts. They're really outrageous. So, but that is what's happening, and you do agree, and people are, finding that that's not what they really want to happen. They agree to arbitration when they don't want to arbitrate, and they have to go somewhere else where they didn't want to go. So when you go to King Soopers and you buy 2 pounds of carrots, what do you click on that says, if I eat these carrots and I get sick, I can't sue you, and you don't agree to anything. You just buy it. But the way things are working anymore, you click and you agree to all this stuff that you never read, and you don't want to read it. I mean, I really don't like reading those agreements, and I've prepared them for clients. They're horrendous. But we're all victims in that way. Any other questions?
This has been incredibly educational, so thank you so much.
I apologize for the volume of the material, but that's just the subject matter. It really takes more than a few hours or so to go over it in depth. But there's so much information that's available on the internet that you can access. It's very helpful. It's just figuring out where to go, and then it's kind of like going into an area where you have all this information, or things happen. It's like sensory overload.
There's probably more copyright litigation in the news than happened.
Yeah. And the reason is because of the cost.
Yeah.
And usually the people who go to, and a high percentage of lawsuits settle, and many times they settle not because of one person being right or wrong, they settle because of economics, because it's so costly. And when people get started, they don't realize what they're getting into until they've gotten into it, and then they say, why am I doing what I'm doing? Because I'm not getting hurt. So I always say to clients, if there's a violation of rights, you need to evaluate where you want to be and what's your objective, and how much is it going to cost you to be there. All right, thank you.
Thank you.
They're good questions.
This was awesome.